Joining us for more on this topic is Evan Leatherwood. He's a Slifka Fellow at the Bernard L. Schwartz Center for Media, Public Policy, and Education at Fordham University. Thank you for joining us, Evan.
It's a pleasure to be here. Thank you.
What I find very interesting about this right to be forgotten law is that Google is being put in the position where it gets to decide, basically weigh that the difference between an individual's right to privacy versus the public's right to know.
Mm-hmm.
It's unusual that a company is put in this position. And what kind of a job do you think they're doing at weighing these two factors?
Well, I think Google is certainly capable of handling all these requests. You said they've handled about 150,000 since the European Court made its decision in May. And they put an infrastructure in place. I think they're taking it very seriously. I think the bigger question is whether or not a private company should be making these decisions. After all, the legal departments of newspapers don't adjudicate libel cases, for example. So why is it that the EU is asking Google to handle the legal process for all these requests? And I think it's important. I mean, I don't particularly like it as a private citizen, and I don't think Google particularly likes it as a private company.
Right.
I think it's giving them a lot of privilege, and the root meaning of the word privilege is private law, and so Google's getting a lot of power, and I don't think that's necessarily well placed.
But as you said, I mean, they probably don't like being put in this position themselves. I don't know what the financial burden is for them, but
right.
Certainly just having to go through all these websites to protect themselves, so to not pay those fines, it is a hassle. Is it unfair that Google's being put in this position? Yes, it is the largest search engine, certainly in Europe, but at the same time, there are other search engines out there. Is it unfair?
I don't think it's unfair because Google is, like you said, responsible for about 70% of the search market in the United States and upwards of 90% in Europe, depending on where you are. And other companies that provide search, like Bing, for example, in Europe, also has to put these sorts of these sorts of processes in place. I think the bigger question is, should this legal process and should this conversation be happening outside of these private companies? Should this be something that's handled by the government? Should the government be the one handling this sort of? It's really a public interest question. It's not something that that I'm comfortable having a private corporation handle.
Right. And at the same time, we're hearing some media outlets are saying they're concerned about legitimate news stories being compromised. They're worried about a type of censorship. What is the criteria under which a news story can be altered?
We're not talking about traditional censorship in that no request that is processed under this law is going to result in a news story being altered. For example, let's say there's a story on the BBC about me that I don't like, that I want taken down. It's only going to be removed from Google's search results. It's not going to be modified on the BBC website or taken down from the BBC website. It's going to be up there as long as the BBC wants to have it up there. And a news organization is going to seek out its own readers, and people are going to go to that and be able to.
So why would news organizations not like this?
I think news organizations might not like it because they feel like it would restrict their ability to get their information out there. There is a certain sense that if it's not on Google, it doesn't exist, and especially when Google handles so much of the search market.
But we need to clarify that. Let's just say this jurisdiction only covers the country in which the request has been made to remove the information. For example, you could still go to google.com and get that piece of information, correct?
Exactly, that's right, yeah. It's very hard to eradicate any information in the digital age, and I think that's
so be careful what you put out there.
Right, exactly. That's part of why this is such an important issue.
Okay, lastly, just the United States is a country that really takes freedom of expression very seriously. Do you expect the right to be forgotten law to ever make inroads here?
I don't. I don't think it's. There have been some legal requests that are similar to the right to be forgotten that have not passed muster under U.S. law, and I think we're so used to having enshrined freedom of expression in the U.S. as opposed to in Europe, where it's treated differently. There's very little chance to no chance at all that there's going to be that kind of law here.
Is that a good thing or a bad thing?
I don't think it's a good thing because I think that the framework of U.S. law was created against the background noise of print culture. That is to say, books and newspapers. And that gives people a very different relationship to information than we have now. The internet, and largely Google itself, has given us this world in which information is no longer scarce, and it's no longer easy to repress. And so I think we need to find a new way to balance these core American values of protecting business and freedom of expression on one hand, but also privacy and dignity on the other hand.
Which is also very important in U.S. culture.
We have to find a new way to balance those two things.
Right, great stuff. Thank you so much, Evan, for joining us.
Thank you very much.
That was Evan Leatherwood, a Slifka Fellow at the Bernard L. Schwartz Center for Media, Public Policy and Education at Fordham University.